14A District Court for County of Washington, State of Michigan is now in session. All those having business before the court are near. The Honorable Judge Judge Simpson and Judge-elect Janana Kamau.
You may, yeah. And before I take the waiver and we get to the other cases, I'm just a matter of just personal indulgence. Sorry for coming out a little bit late, but it is, for me, this is a very joyous occasion having Judge-elect Kamau with me. Many don't know, she was a student of mine, which now ages me. But also I had the pleasure of swearing her into the bar. And on both of those occasions, both as a student and in swearing her in, I knew she was somebody special and that she was going to rise to levels that one may not be able to imagine. This is a stop along the way, but this is an incredible person sitting next to me, and it's a joy having her here. So I want to say that. And she likes me, unlike the rest of you. Calls the case. People versus Kyle Rainey.
That's a lot of good people.
Hey, Judge. Court shall please assistant public defender. Can I ask Mr. Rainey? How are you?
Going pretty good.
This your case?
You said Kyle Rainey?
Yeah,
This mine then, yes.
it is.
Well,
Okay, go ahead.
today it is.
Yeah, that's fine.
Thank you. We're trying to get an offer on this file that Mr. Rainey would be happy with. Not yet been able to negotiate that with the people. I'd have to motivation and try to get the offer that
You get that done by the second, you want the 9th.
the second should be fine, Judge.
Probable cause conference, January 2nd,
Can I
2025.
say anything? Hey, Judge, can we kind of, I want to try to come to some kind of agreement today. I've already done 6 months on this case. You know what I mean? I came from one jail, got PR'd. They came and picked me up. I did my time over there and I only got a 3-month charge over there. They said they would release me earlier to a probation center. I didn't get to do that because you guys had a hold on me. I sat in there, then they came and picked me up after I got done with my 6 months, brought me here, and I've already sat for a month and have been adjourned twice now.
Okay,
I've never
I don't-
been in any kind of drug charges.
sir, hold on before you go on. I don't know anything about that. It would be a bit hard for a resolution to happen today.
I did a
My
by
understanding
mail.
at the last hearing, they were attempting to try to get mitigation information over to the prosecutor. If they got that over to the prosecutor, prosecutors are gonna take that into account and trying to formulate some deal.
Because technically, it's
I
my
don't-
first drug charge via 7411. You know, what I mean, I've never been in on any drug charges. I do have charges for like a CCW.
Sir, what do you want me to do?
I want to try to get this taken care of. I got a family at home that I'm trying to take care of. Or at least be able to get a PR so I could take care of my stuff. I've been locked up almost 7 months now. I got 3 kids at home. I got a dog that's about dying. I got a property that I take care of. I run a business. I just want to try to get some kind of leeway so I can take care of the stuff that I have to as a man. I don't have just family out there that can be just taking care of my properties, taking care of my job. I was a business owner. I went through a divorce and made some mistakes. I'm not trying to pay for it for the rest of my life. I'm going to lose everything.
Would you please take that, Judge, as a bond request on behalf of my client?
Any response from the people regarding,
Your Honor, in June of 2024, the defendant failed to appear and a bench warrant was issued. It appears that he was picked up on that in late November 20th, 2020.
so what happened with that? Let's stop there.
Sir, I left here, got picked up from Hillsdale County. They picked me up. I've been in jail ever since and then got brought here. I
Do
didn't. skip out
do
on
we
court.
have a showing? You know what? Chill,
Yep,
chill.
I understand.
Sorry, Judge. I did discuss this with my client. He did suggest that he was in Hillsdale County when that.
Here's what I'll do. Let me do this.
Yes, Judge.
Because you got to teach him how he addresses a court.
Yes,
I
First
apologize.
of all, no, you're trying to force your way to do stuff. And I'm just going to tell you, you first of all were gone for a very long time from this court when I had it, and we didn't hear from you. So you might want to check how you're operating with me because I don't have to do anything on this case today.
I understand, sir.
So what I'm going to do is I'm going to pass it, take him back. Mr. Priest, I'll give you an opportunity to talk with him, look at and see whether you can verify what information he's giving the court so the court can get his file.
Thank you, Judge.
Thank you. Oh, they did, okay. Court recalls the case People versus Kyle Rainey.
Ready again, Judge. Court shall feature Assistant Public Defender appearing on behalf of Mr. Kyle Rainey. Mr. Rainey, please state your name again for the record.
Kyle Rainey. Hey, I apologize for my actions, the way I acted earlier. Just a little, frustrated.
Thank you, Judge. So if we may revisit the bond that. Mr.
Yes,
Rainey-
go ahead.
Thank you, Judge. So I did have a chance to go do some research on what Mr. Rainey was arguing. It does appear that he was granted a personal bond here back on June 6th, and he was then transferred to Hillsdale. He was in Hillsdale custody until November 20th. He entered a plea on that file in Hillsdale on September the 9th. His sentence there was 6 months, which is how we got to that November 20th date. He was then transferred back to Washington County because he had missed the court date here and received a bench warrant while he was in Hillsdale County Jail. And so now he's been here for another month, which is the total of the 7 months. But he was talking about, to confirm that I did have my office call Hillsdale County Jail, and they did verify that was the Deputy Jimenez at the county jail.
He was there
Yes.
during the time that he was missed. Got it.
Yes, Judge.
Okay.
And so he's hoping that the court will consider a release. He wants to resolve this matter, whether that be with a potential misdemeanor or 7411, but he's not running from this case. But at this time, Ms. Londy's still considering some options in terms of a potential plea resolution, is my understanding. And so we're not ready to resolve it quite yet. We're just hoping you might consider bond.
And that's correct, Your Honor. It's my understanding that at the time that the defendant was in Washington County Jail and then eventually went to Hillsdale, he had a hold from Hillsdale for a hearing concealed on the case.
And that's what he ultimately pled to. And
that's what the time period was.
that's when he served the 6 months for that, and now he's on 2 years probation to Hillsdale County.
Yes. So I don't have an issue adjourning it, seeing if we can work something out. The concern of the people to resolve today is that there was that other felony that just happened and has now been pled to. So we want to dot our i's and cross our t's for how to resolve this case.
Got it. Okay, let me do this then. I'm going to adjourn this hearing out to January 9th, 2025. $25,000 personal recognizance bond, but he must be placed on a GPS location tracker prior to his release.
Thank you so much, Judge. Very much. Judge.
And see, sometimes, sir, if you just talk to your attorney and close your mouth, that was done in far less time than it took you to go on your little ramble tirade. Thank you. Have a good holiday. Court does call the case of the People versus Michael Clumpton.
Morning again, Your Honor. Michael Vincent on behalf of Michael Clopton.
Your name, sir? Michael Clumpton.
Yes, right now there's no bond for reasons I'm not quite sure on. He has a bond. He had a bond of 5,000, 10%. He was in here earlier and basically he got afraid that they were going to ask for a $250,000 bond and left. But he has since turned himself in.
Oh, yeah, I did that.
I'm not surprised.
Yeah, you shouldn't be.
I'm not.
So he was here, did not appear for his proceeding and left.
Yeah, he left. Or
Yep.
Say Ypsilanti, they left home.
And I revoked his bond
Yes,
back.
but I'm asking for the
So
bond.
now we
fee.
have him here.
He's here, his employer's here, Jonathan Hunt, he works full-time for Mr. Hunt. Mr. Hunt, could you stand up so the judge can see who you are? I'm not making this up.
Hello. I believe that you're not making it up.
So, I'm asking for a
He
relatively.
shouldn't have left. I mean, I'll
I
let you
agree.
go on, but he shouldn't have left. I mean,
I totally,
there is nothing really that I can think of that's going to indicate that he's a flight risk more than that.
well,
But I'll let you go. Go ahead. What?
I've been retained, he's listening to me. He can be tethered to his job, tethered to his home, and that's it.
Response from the people.
Thank you. I am stuck on the I am stuck on the he turned himself in part. I don't understand that because he was arrested in Canton, Michigan.
I thought he turned.
Oh.
Fit.
So not only did he leave here, he didn't then change his mind, come back, turn himself in, he got arrested. What was he doing when he got arrested?
He's innocent until proven guilty, Your Honor.
He is.
So when we were here in May, I told the public defender that I would be requesting a $250,000 cash surety bond.
That's right.
The public defender went out to the hall to speak with Mr. Clopton to advise him of the same and essentially to prepare for their defense for that argument. Mr. Clopton ran. At the time that the case that he is in custody for with bond denied, at the time that he was arrested on that file initially back in July 2023, while he was being searched by the police and when the police found cocaine in his possession, he told the police, I have a warrant for my arrest.
That's right. That might.
He knew that he had a warrant for his arrest and again, did nothing to resolve it. When they asked him, what do you have a warrant for? He said, just drugs. He has a criminal history that includes, sorry, I already pulled up in front of me, multiple drug charges, convictions. He also is the subject of, and I feel that I can disclose this because the search warrants have already been executed. He is the subject of an ongoing statewide trafficking investigation. I am meeting with the law enforcement agencies next week to determine where that case is going. But his criminal history in terms of drug trafficking begins in 2006, where he was convicted of delivery of manufactured controlled substance. He was sentenced to a jail. Again, in 2006, he was charged with delivery manufacturing. In 2007, he was convicted of home invasion in the second degree. In 2011, he was convicted of fleeing in the third degree. I could continue on, including 2020. He has convictions for firearms, including CCW, possession by a felon, RMO, and that is his most recent conviction, at least as far as I can see from his lien. And because he was out on a drug case with the bench warrant, knew of his bench warrant did not meet, and the ongoing investigation against him and his associates, I had planned to come in here and make an argument for $250,000 cash surety. Today, he should not get the benefit of that argument. His bond should remain denied. Your Honor.
Anything else, Mr. Benson?
Waiting to hear on the statewide investigation, but he's not charged with that.
Oh, I understand that, but I also understand that he was here, left, did not voluntarily come back or change his mind. We now have him. He's a suspect in other things. And he didn't turn himself in.
What?
He's a flight risk.
I mean,
Clearly.
he told the cops that, look, I got a warrant.
And did nothing. Motion for bond reduction denied. Bond will continue as it's set. Thank you. Okay.
We just call with.
All right. What are we doing?
We asked the court to set this matter for exam, and I humbly request that the same day, the 7th date, if that's available. This case.
Your Honor, we've talked about this before in this case. Unfortunately, the defendant is still pending competency in a matter of 15th. He's scheduled to have a pretrial on that matter in January. But I understand as I looked at the file today, it appears that his evaluation was scheduled for October the 28th in his 15th file. He was arrested and remanded on this case on October the 24th. So he was unable to keep that appointment. And I don't see that he has had that rescheduled. So I'm not sure if he can proceed to examination while competency is an outstanding issue on a different file. Just wanted to put that before the court so everybody was aware that that's what's going on.
Based on my dealings with the forensic center, when you miss, you have to do another order for competency. I've spoken to my client. I don't represent him on that case. I don't know if another order is done. I have no issues regarding the competency of my client in this case. We've been able to talk about the nature of the proceedings and everything pertaining to that. He's charged with felonious assault based on my preliminary scoring of the guidelines. Based on all the adjournments because of this other case, we are getting to the point where he's served pre-trial the amount of jail time that I would expect if he was convicted. So if the court does think it's best to adjourn these matters, I'd ask for a release of my client on this file, yeah.
Are they expecting a report back soon on that?
Because he missed his evaluation, because he was in custody, he's going to need to be re-referred in 15. He's going to have a new order and a new evaluation done. The concern of the people is if there's a question by anybody that represents the defendant about his ability to understand the nature and outcome of proceedings against him, I certainly don't want to proceed forward with a preliminary examination. I definitely don't want him to go forward with a procedure or a process that he may not fully understand. First and foremost, it's fundamentally unfair to him as a defendant, but it's also a huge issue with being able to continue with the case forward if there's a question as to competency.
Can anybody from the public defender's office help? Thank you, Mr. Feaster. Yeah, no, go ahead.
Stephanie Cannon on behalf of Caldwell as it relates to his 15th district court matters. And Your Honor, no, when I emailed the forensic center, they just said that they would reschedule time with him. At that point, they hadn't, because he had only missed it by a day. And they told us they were going to reschedule it.
And use the same order.
Yes.
Okay.
However, if they need a new referral, I can go ahead and have one submitted. But at that point, they said, thank you for letting us know. We will schedule time with him.
And
but I'm hearing that they have not done so.
And they haven't done it yet.
It is my understanding based on what has been said here today that they have not done it yet. I can tell the court that at the time when the referral was done and I tried to have a conversation with him, he was not doing well. He was not medicated. Things were not well. And in speaking, he has a guardian. Last time I checked, he had a guardian. And in speaking with her, she had her concerns, which is why we did one then. But this was maybe 3-4 months ago when this happened. If he has been medicated since then and things are going better, I don't know. I haven't spoken to him since that incident. So at the time, I do believe a competency evaluation was necessary.
And Your Honor, the letter that I do see in the file for case 2335 SM for the Honorable Judge Perry says that that he missed his evaluation. It was an order dated in June 27th, 2024. He missed his appointment on October 28th, 2024. In accordance with MCL, et cetera, this is a request of attention of the defendant. If the court honors this request, please notify us and we will coordinate promptly with the sheriff for evaluation via video conferencing. Otherwise, we will take no further action. I skipped a little bit in that rest of that sentence. So I don't know if the public defender, if they were copied on this letter, I can see that it was sent to public defender's office, but I'm sort of stuck until it's rescheduled.
Your Honor, we have an email from Lisa, and I'm sorry, it doesn't put her last name in, and I can't tell you. It says, thank you. I will coordinate his appointment with the Washtenaw County Jail for next week. We got this email on November 18th. So based on that assertion, we did not redo it. We will, but again, I haven't spoken with them since then to see if things have.
So they were going to redo his appointment that week, but did not.
They did not, apparently.
And my letter is dated November the 13th. So that email is after the letter came. So I'm really hoping we can get this sorted.
Oh, MUI, yeah, Lisa, yes.
Listen here.
So she emailed us with some different information than what.
Oh, really?
Yeah.
So is she here?
She's
But is she in the building?
in the building, yeah.
Okay, so when is the next date in 15th?
January 15th.
Okay, because the problem is the PD, I was just informed, you guys withdrew on that case.
Oh,
So you guys are no longer on it. And then, but thank you for all the information. Miss.
Oh, and it says it right there. Yes, Your Honor, that is correct. We withdrew.
Feaster gave that to you, didn't he? Feaster gave that to you. I saw it. No, Miss Cannon, I saw it. Mr. Gaddy sent you up there saying, yeah, go talk to him. and then Feaster gave you that, and they just set you up. It's okay, Ms. Cannon. I don't hold it against you. I know. No, it's Gaddy's fault. And then you just jumped on the pile. Here's what I'm gonna do, and Miss Cracher was. Young man, have you talked to Miss Cracher?
I don't even know who that is.
Even better. Okay, here's what I'm gonna do.
Have you talked to your?
I am on the court's own motion. I'm gonna find good cause. I'm gonna adjourn this probable cause because I want to get to the bottom of everything with regard. On his 15th district court case, can anybody tell me what his bond might be?
He failed to appear, so he may have a warrant. I don't know. That is correct.
We're left on one. We have one left.
You have one what left?
We are left on case 20-0361 SM. All the other ones we did withdraw.
That other one is over in 15?
Yes, Your Honor.
Oh, Lord have mercy. Okay.
It looks like 10,000. 10,000. So it's being held on.
He's being held on that.
Yes.
Okay. But that was for his failure to appear. Do you know?
I see there was at one point a warrant entered and then he appeared after that.
And then he appeared after that and his bond, and he's got a bond of 10. 10. Okay. All right, here's what I'm gonna do in this case. Court on its own motion, finding good cause. I'm gonna adjourn the probable cause conference to the date after says 15. I'm gonna give you the 16th if he's got to appear in 15th on the 15th. So I'll set it for January 16th. In the meantime, everybody can maybe figure out exactly what's going on with all of his cases. Because if they withdraw it, if they withdraw the request for competency at this point, then everything can go forward. But I think this is a safer way to do it.
Yes, sir, Your Honor.
All right, thank you.
Stephanie Cannon on behalf of Abbott Warren. Warren Abbott, sorry, Your Honor.
You guys are close, huh?
It was fine. Hi, Your Honor, how are you this morning?
I'm doing great. This is your case, all right?
It is definitely my case. I just couldn't get here, Your Honor.
I didn't know. But
My case.
so the last time you were up here talking to me,
Yes, sir.
that wasn't your case.
No, it was.
And then now you're up here and this is your case. You don't have a client, do you?
So, Your Honor, I'm just going to ask for an adjournment of today's proceedings
I know you are.
to see if my client can make it here.
Bench warrant will issue. Bond is setting him at a 10,000 cash surety. That warrant will issue immediately.
Thank you so much, Your Honor.
Thank you. Having a good day.
So happy. Whole row right here.
You look happy, but I'm gonna change that.
We'll show Feaster, Assistant Public Defender, appearing on behalf of Ms. Emily Bates, who is normally by Zoom.
Ms. Bates? Hello, state your name, please.
Good morning. Happy holidays, Your Honor.
Happy holidays to you.
Thank you, sir.
Thank you, Judge. This is a case where I'm trying to get some information from a probation agent and an out-of-county probation officer to provide to the people to hopefully get this matter resolved. I have not yet received that information from her probation officer there. Her father is trying to help me get that information. And so I'm asking for another 2-week adjournment if I can get that out to get this matter resolved.
January 9th, 2025,
January
9 a.m. Bond continue.
January,
Thank you, Judge.
can you, I don't understand. January
Pardon?
2025. January 9th. Wait, thank you for your
Yes.
patience. Thank you.
Your proceedings being adjourned to January 9th,
Okay.
okay? Because Mr. Feaster, your attorney, is trying to get some information.
Oh, thank you. And I appreciate that. Can I ask you a question, Your Honor? I would like to
Yeah,
give
go
you-
for it.
Thank you so much. it's okay to send you a report of what my accountants of what had occurred and not occurred in regards to this matter personally?
Pardon?
Then she wants to send you personally an accounting of what happened in this case.
Or
She
should
She wants to send me something?
Sure,
That's
yes,
what she's
sir.
saying.
Or take
Okay, so you can't do that.
just send it through my lawyer?
Yes, you talk to your lawyer
Okay.
and they'll figure out what information needs to get to the judge handling the case.
Okay, because I just want to make sure that you read the report if it's given, that you read what I give you.
Okay, but if I will read them, if both the prosecutor and your attorney believe I should see that, then I'll see it.
Okay. I mean, why?
Okay?
I see why. It would be accountant of the truth if you want to know exactly what happened. Then I want to make sure that, but make sure I do it through the prosecuting attorney and my lawyer.
Well, do it through your lawyer.
Okay.
Okay, make sure to
Thank you.
get everything to your lawyer. They'll decide who it needs to go to and who should see it.
Okay.
Okay?
Okay, and what exactly are you requesting, sir?
Am I requesting? I've requested nothing.
No, not
However,
you,
your
not you, my
attorney's
lawyer.
request.
Your Honor, no, Your Honor.
Right, but why don't you guys have that in private,
Okay,
that conversation?
okay,
And then he'll be more than happy to tell you.
okay, thank you.
Thank you. You have a great day and holiday.
Happy holidays. I hope you have a beautiful, beautiful Christmas. Thank you, Your Honor.
Yes, ma'am. And Alan turned down the heat and it's cold up here. Both of us. You get too hot? We don't care.
Aw.
It's important that we're comfortable. People don't get this. Don't get how this works. Like we should have fluid. It's okay, man. We have days like that. Court calls the case People versus Latasha Brock.
Good morning, Your Honor.
Good morning.
Good morning.
Stephanie Cannon on behalf of Ms. Brock. Ms. Brock, could you please state your name for the record?
Lastasia Brock.
Latasia.
Lastasia.
Yes, it is. Latasia. I got it. I looked
Thank
at it
you.
wrong. I'm sorry.
They always do.
Okay, what are we doing?
Your Honor, my client would like to have a preliminary exam in this matter.
All discovery is complete.
Do you want to entertain a misdemeanor offer?
I want to entertain that, yes.
Okay,
Your Honor, may I have just 1 second if the court we just.
I had sent an email. You want to do a brief adjournment at PCC, I suspect I could probably offer.
Your Honor, there may be an offer extended, and I understand that he reached out to the victims regarding this or complaining witnesses in this matter. Would you be okay with the adjournment of this proceeding, Ms. Brock, or do you still want to exercise your right to a preliminary exam?
What was the first one you said?
We can adjourn this. I know when we discussed it yesterday, you asked for a preliminary exam, but there may be a possible resolution to this shy of that. And I'm just asking if you would like to adjourn it for that purpose, or do you want to go ahead and have your exam?
What would be best for me to do? What would be the right?
Okay.
Your Honor, we're gonna adjourn it.
I'm not gonna have that. You're not gonna have that discussion in open court, okay?
I
Okay,
agree.
Brock, so what I'm going to do is I'm going to adjourn this out a couple weeks, let you talk with your attorney and see which way you want to go, okay?
yes, sir.
Fair
That
enough?
sounds, that's fair. Sounds good.
Okay, well, thank you. I try.
And what
So-
would be the, I'm sorry, what would be the date? And would this be in person or would it be on Zoom? Because I'm on a home invasion GPS 7 right now.
Oh,
Yeah, Ms. Brock, if you could just let me ask the questions, please. A
I know.
little bit.
Okay.
Your Honor, just
that kind of makes us look different.
doesn't it?
Miss Cannon, you are having a great day.
Thank you, Your Honor.
January 2nd, 2025. 9 AM.
Thank you so much, Your Honor.
You're welcome.
Would it-
I'll continue. January 2nd.
Would
So
it be
talk-
on Zoom?
Well, we might have to do it that way because I don't know that you can be going places.
Right,
I will make the
can't.
request.
So, all right, no, it's okay. So here's what you do. Talk with your attorney
Okay,
because you're kind of locked down right now.
yeah, I'm on lockdown for sure.
I know. So nobody knew that until you said it.
Yes, I'm confined to my house.
Yeah, confined to the house. Just it.
The
Thank you.
best,
So you know what? I'll shortcut it. We'll let her appear via Zoom.
Thank you.
And
thank you, Your Honor.
all right, because we don't need the form. She gave us everything we need in the form.
Thank you, Your Honor. I appreciate
You're
it.
welcome. You have a great holiday
Thank you, you
in your
too.
house. All right.
Thank you.
Clerk
Maybe
calls the case.
No, I'm like, she's having so much fun. This is like Christmas. I love it.
Exactly. Clerk calls the case. People versus Robert Jobaszewski.
Good
Uh-oh.
morning, Your Honors. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Lauren Brown. On behalf of Mr. Robichewski, who is appearing to my right, please state your name for the record.
Robert Jobaszewski, good morning, Your Honor.
Good morning, sir. Oh, quit saying that. She can handle it herself. Permission to practice is granted.
Thank you, Your Honor. We reviewed the forensic report this morning and we have no further evidence we'd like to present to the court.
Regarding his competency.
Yes, sir. The people also have nothing.
I'm sorry?
The people have nothing further to offer and would stipulate to the report.
All right. Do you have an order?
Yeah, we received it this morning. We will get it to your office by the end of.
So you don't have an order?
Not physically, no.
Did Mr. Brown tell you that when you call the case, he should have an order? He didn't tell you that, did he?
Well, he.
He was trying to
mentioned-
set you up.
No, he didn't, wasn't.
No, yes, he was.
He said that we got it this morning when we got here, so we did not have time to give it to you, and we will by the end of the day.
Why are you trying to cover him? All right, the court, having no further evidence, the court having reviewed the report, court would find that the defendant is indeed competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. And counsel, what would you like to set
We
for?
would like to set this matter for probable cause conference.
He told you that.
He tells me all of it. It was all right.
He was trying to set you up. I'm telling you. Telling you right now. All right. Probable cause conference. Would the 26th work?
I believe so, Your Honor.
December 26th, 2024, 9 AM. Bond continue.
Thank you, Your Honor.
Thank you. Thank you.
Have a nice holiday, sir.
You do the same.
Thank you very much. Y'all have a nice holiday.
Your name?
Robin Lee Finney.
Thank you.
Thank you.
Esteban.
Esteban, Your Honor, it's my understanding that Ms. Finney was before Judge Perry yesterday. I don't know whether the bond was amended over there. I think it may be lower than it was. However, she's sitting currently on $200 and $100 apiece on both cases. My
On
understanding.
the cases out of 15.
Two. I'm sorry, did you ask how many cases out of the 15?
No, the bonds that you were giving me were the cases in 15.
Yes, they were.
Okay, go ahead.
Correct. She's currently sitting on a bench warrant on this case for $25,000. It's my understanding that she missed a court date. She wasn't aware of a warrant. However, she was picked up on the charges in the interim.
Correct, but she also has another issue.
She does have a hold out of Van Buren Township that I'm aware of, Your Honor.
Okay, that's not the one I'm talking about, but thank you for sharing.
Well, yes, but we are not expecting her to be picked up on that writ, however.
Okay.
In terms of the other issue, I suppose I might not be aware of that, Your Honor.
And that is that when she was previously released.
Yes.
She not only did she not appear for court proceeding, She also didn't report to community corrections as ordered.
I am asking for a Christmas miracle, Your Honor. I'm asking for a PR bond in this case. I have a good number for Miss Fenny. She advises she can report to community corrections. She had.
That's where I say bond, but no, go ahead. I'll let it finish.
Your Honor, while she was told about community corrections, she advises that she didn't remember or she just didn't know to report over there.
Here's my problem. She didn't go to community corrections. She didn't appear for a court proceeding. Then she doesn't voluntarily turn herself in. She's picked up, and that's the only reason she's before the court.
Your Honor, she did.
And she has all of these other pending matters, but you can go ahead.
Your Honor, she has 2 other pending matters out of the 15th. I talked to the prosecutor. There were other potentially pending matters. However, those were denied. I'm not expecting any more cases out of her. With regard to community corrections, she is obviously willing to go over there. She gave me a good number that I can contact her on. She's willing to do a tether, whatever the court would impose and find appropriate. I did ask for a Christmas miracle today, so.
Yes.
Yeah, that she's been up to are she benchmarked here on October 10th. On October 20th, she picked up a new assault and battery case. That's one of the cases on the $100 bond for.
So she committed or allegedly committed an offense while she was on bench warrant status in this case.
And then again, after that, on December 6th, and I will use the word allegedly at this point because that case has not been charged yet. It's in further status for the body camera. She assaulted a police officer. So that is a warrant under review. So that one may still be coming for an RNO.
Your Honor, I would advise that I really do appreciate, I picked up the words that Ms. Hughes was putting down and the word allegedly stuck out to me the most. And I really do appreciate that one. In all of that, I would.
It means Bellinger's ignoring all of the other words. I'm going to hang on to the ones that are good. Bond will continue. I'm going to deny your request.
Thank
she
you.
hasn't done anything she's supposed to do and is out there allegedly committing other offenses.
Alleged.
Yes. Well, thank you.
Thank you. All right, we'll see you on the next.
You tried.
Tried. Yes, he did.
I don't know if that was an insult to me or.
I don't think she was saying you tried allegedly.
She's still talking.
I can't. Can I go home?
I think you need to stay, see if you can get a Christmas miracle. That wasn't it. Corco. Bellinger, what are you doing?
I don't know.
Okay, all right, fair enough. At least answer honestly. All right. Court will stand in recess and then we'll get started on our next block at the appropriate time. Thank you. Court's in recess.
Judge Torshall Feast, Assistant Public Defender, on behalf of Mr. Lewis, who is not present, but I do know where he is.
Okay. Help us all then.
Thank you, Judge. I was texting with Mr. Lewis all morning, asking him where he was at. He said he was on the way via city bus. Then I just got a call from him saying he was at court, but it was locked. And he indicates that he is at Judge Valvo's court at the 15th District downtown.
This is like that same thing that happened last time with one of your clients.
It is very similar.
I know.
Yes.
It's a pattern.
I don't.
The notice on top says 15th. but
Yes.
it directs them to go here.
Yes, and so that's what he just sent me via text, a picture of the notice.
Oh, you're gonna join in on this, huh?
It does say 15th Judge, City of Ann Arbor. It does say Judge Alvo, and it says today at 9 a.m. So he went to the wrong place. And I guess if I had known he had that notice, I would have corrected him, Judge. I did not know it said that. So I am requesting a permit based on. I'm sorry.
Is he coming here?
I mean, he's on the bus.
He's what?
He's by bus. It would take him, an hour or so. I assume.
So when did he start coming here? Or did you tell him,
I
no,
told him
I'll
to
take
stay
care
in
of it?
Valvo until Judge tells us what to do. So he should be at 15th right now at Valvo Court.
Please, sir, what did you think I was gonna tell him to do?
I didn't know if you want him to try and get on the bus and get down here, or if you were gonna be willing to adjourn it.
When have I ever done that?
Well, he just said it like 2 minutes ago, so he wouldn't be here by now, Judge. I figured you'd call it and I'd get some direction. I'm sorry.
Do people have any objection to me adjourning this, or do you want me to?
No, only because he did it last time too.
Okay.
Yeah, that's what I'm talking about.
Not know now.
What's up with that?
I do believe Mr.
Yeah, I didn't.
I
have it
don't.
last time. I didn't have it last time, Judge. I'm sorry. I didn't know that that was a pattern for him. But now that I know, I can make it very, very clear where he needs to be, Judge, and it will not happen again. There were no notes warning me about this from last time, Judge. I'm sorry. Oh, and Mr. Gaddy says he actually does have a case with Judge Valvo also. So that's probably.
Why is he sticking in like?
People are saying things, it's like the telephone game.
Give him 1 week.
Okay.
If he comes in saying he went to the wrong place, I don't care where it is.
Okay.
If he went to KFC across the street, I'm issuing a bench warrant.
Fair.
All right.
Fair.
Continue.
Thank you.
The recall.
Call him right now, Judge.
What?
Call him right now. This address. Make sure he knows. Very clear, Judge.
Better make sure they.
Court. Court does call the case of the people versus Nathalie Mason.
Actually, for the people.
Good afternoon, Your Honor. Alexis Earps, Assistant Public Defender Fellow on behalf of Ms. Mason, who's approaching. Ms. Mason, please state your name for the record.
Nathalie Mason.
All right, what are we doing?
Your Honor, we'd be asking for an adjournment. We were potentially trying to reach a resolution, and it doesn't look like that's going to be possible anymore, so I need to discuss next steps with Ms. Mason.
How much time did you think you needed? I'm sorry.
2 or 3 weeks, Your Honor.
All right. Probable cause conference, January 9th, 2025, 9 a.m. The bond in this case will continue. My understanding is there's a warrant out of 15th District Court.
Your Honor, I did discuss that with Ms. Mason. I told her that she could potentially go over to 15th today to do a walk-in arraignment with Judge Perry, but she's not sure if she has enough bus fare to get over there because Judge Perry does really do walk-ins.
It is the understanding of the people, split, Your Honor, according to JIS, it appears there is an active warrant in case 24315 SM, which is another retail fraud matter. It appears it was entered in November.
And Your Honor, if I'm understanding correctly, from speaking with other individuals in my office, she had court a pretrial in front of Your Honor for a 14A1 case, and then she also had court in front of Judge Perry on that case, and she may or may not have been on Zoom and then logged off prior to her case being called.
And that's correct, Your Honor. I'm not sure why the warrant hasn't been cleared. That was a little bit ago. The court may remember that she had the active warrant for this felony case and was supposed to be before this court for a misdemeanor matter. She came to court as the court directed her and then had not appeared in front of Judge Perry, but that warrant is still active now. So I wanted to make sure the court was aware of it.
Yes, Ms. Mason.
I had court with you and Judge Perry on the same day. My attorney told me, which wasn't her, it was the lady the last time I was here, told me to come here. I better show up here.
So she told you to choose me over Judge Perry?
I mean, it was at the same time.
Huh?
Hers was at 9:45.
And so you came here?
She told me.
Well, but you came here. You came here to see me. Ms. Mason, can you get that warrant cleared? I normally would take somebody in, but I know you're trying.
What do I have?
You keep trying to get from one place to another, and I know you make efforts to do it.
Yeah,
And
I don't want warrants. I show up before.
I know and you'll get there eventually. I just need you to get there when you're supposed to be there. So your attorney should be able to help you clear that warrant. I'm not going to take you in on that warrant. Okay. And you just get over there and get it cleared. Don't come back here before me and that's not cleared up. You hear me?
Yes, sir.
On the 9th. I'm going to trust you.
Thank you, Your Honor.
All right. So, yeah, that's it. That's the public defender's been looking for a Christmas miracle. You're it. All right, bye.
Thank you, Your Honor.
That's the only one. What?
So what about on one of my cases? I asked.
That Bellinger is never gonna happen for you. It just isn't.
So if I ask for arrest, will you just give me a Christmas miracle instead?
An arrest?
Opposite day?
An arrest of you?
No.
Oh.
I
I thought he was gonna make my Christmas wish come true. Court calls the case.